Hello, my name is Jonathan Cary. I'm a partner in RPC's Hong Kong office, where I focus on disputes, investigations, and contentious regulatory work. And I'm going to be talking briefly about a topic which is really of absolute fundamental importance to the provision of legal services, and that is legal advice privilege. And in particular, looking into the international context and the gulf that has developed between England and Wales on the one hand, and the other common law jurisdictions such as Singapore, Australia, and in particular Hong Kong over a recent period. Now, of course, legal advice privilege is fundamental to a lawyer's work and also the interests of a client on the basis that it protects from disclosure communications between the lawyer and the client. Until fairly recently, it was fair to approach things on the basis that there was no real difference between the common law jurisdictions, but all that has changed. And what we now see is England really standing alone in relation to its approach to legal advice privilege and the very restrictive approach that was taken by the Court of Appeal back in 2003 in a case called Three Rivers No. 5. And what Three Rivers No. 5 did was greatly restrict legal advice privilege by stating that the client, for the purposes of legal advice, is not all employees of a corporate, for example, but instead it's only those specific individuals who have authority to provide instructions and to receive legal advice. And that gave rise and has given rise to some real practical issues for both lawyers, in-house and external, and also corporates themselves. And in particular, what we see in the investigations context is concerns around the taking of interviews on the basis that when a lawyer is instructed to conduct an investigation, most normally they're only able to get to the bottom of things by talking to the employees to find out what might have happened before they can provide legal advice. And the issue there is that those employees may not form part of the client for the purposes of assessing legal advice privilege, in which case those communications may not themselves be privileged, and notes, for example, those interviews may also fall to be disclosed. Now, those practical difficulties have been recognised in all of the common law jurisdictions, or the major common law jurisdictions, as I said, apart from England. And most recently in Hong Kong, in 2015, it was addressed in the case of CITIC Pacific. And what the Hong Kong Court of Appeal did is not only did it declined to follow the very restrictive approach taken by the English courts, instead of set up a new test, which is what we call a dominant purpose test. And that gave rise to a hope in England and Wales that the English courts may follow suit. But instead, what we've had over the last 6 months or so are 3 cases in quick succession which have endorsed that restrictive approach from Three Rivers. And so we're now in a position where, as I say, we have a gulf between the English position and those in other jurisdictions. And what that means for corporates is that they must be very much alive to those differences and to understand them, because they do present real risks and pitfalls. As we've seen from the recent cases in England, those pitfalls can be very serious indeed.